Thanks to the internet and global trade, nowadays we can buy pretty much whatever products we want, from just about any location in the world. Once upon a time, this was not the case. Consumers in each country were only able to purchase items which importers had decided to sell, and often those imports were heavily taxed to protect inefficient local manufacturers. The result was massively inflated prices for consumers. In this case, Mr. Salomon had travelled to the USA, and there he had purchased a Polaroid camera. In the 1960s, a Polaroid camera which instantly printed photographs represented high technology. He had paid the equivalent of £30 for the camera. The same camera was for sale in the United Kingdom for more than £90. You can see how badly these tariffs resulted in people being ripped off. When he returned to the United Kingdom, customs agents imposed an extortionate tariff, which would have cost almost as much as the camera itself. Mr. Salomon contested the assessment, and the court had to apply the Customs Excise Act 1952. The United Kingdom was also a signatory to a 1950 treaty called the Convention on the Valuation of Goods for Customs Purposes. It was clear that the Customs and Excise Act 1952 had been written to implement the convention from 1950. However, nothing in the legislation explicitly said so. One question before the court was whether, in the circumstances, the court could use the convention as a basis for interpreting the statute. The court determined that it could do so. Lord Justice Diplock said, "If, from extrinsic evidence, it is plain that the enactment was intended to fulfil Her Majesty's government's obligations under a particular convention, it matters not that there is no express reference to the convention in the statute. One must not presume that Parliament intends to break an international convention merely because it does not say expressly that it is intending to observe it." Of course, the court must not merely guess that the statute was intended to give effect to a particular international convention. The extrinsic evidence of the connection must be cogent. From this case, we confirm the principle that while international law can never bind national law, if national law is made in order to implement an international obligation, it makes sense to take account of the international instrument when construing the national law.